right. Good afternoon to everybody. Welcome to the Credit and Collection News podcast. We are honored today to have someone who I've known for a long time. Ashley has been a friend. He's been a coworker. He's been a speaker. We've kind of known each other, like I said, for 20 plus years. He's one of the first speakers that came to the Credit and Collection News Conference years and years ago. But I'm honored to have Ashley Taylor here. And just a little background for those of you who don't know Ashley. Ashley is the co-leader of Troutman Pepper's nationally ranked state attorney's general practice, vice chairman of the firm, and a partner in its regulatory investigations, strategy, and enforcement, which is the RISE practice group. They just celebrated their 20th anniversary of the state AG team. Ashley is also a former Deputy Attorney General of Virginia, I believe, because I'm going back on memory, and God knows my memory is not quite the same. But I do remember, if I remember this, and this is going to age you, but I believe you were the youngest Deputy AG at the time. So I don't know if there's been a younger Deputy AG since then, but I know you were holding that record. Um, from an education standpoint, he got his Juris Doctorate from Washington and Lee University School of Law back in 1993, and he got his BA from Virginia Military Institute in 1990, where he also played football. And maybe you'll tell a story or two about playing against Alabama way back when. Hey, with that, I welcome Ashley to the podcast. You didn't know I was going to throw all that extra
I
stuff
did
in there.
not. I
Kind of,
did not. Well, thank you, Steve. It's been a pleasure to count you as a friend and a colleague over the last 20 plus years. And congratulations to you on all the great work that you do in Credit Collections News Conferences. General reputation as the place to go for quality information, current trends, and general networking for people in the industry. So congratulations for all you've done and everything you've built over the past 2 decades.
Thank you, thank you. It's like I said, it's an honor and a pleasure, and glad we'll be bringing you back for a few of our shows because hey, it's been a little bit of time, but I'm excited to get you back.
It has. It has. We're going to have a couple of panels at your next conference, and those panels will include, as they always do, several regulators as folks that will either serve as guest speakers or people we interview, and we will have among them certainly one or two state AGs and state AG staffers, some chief deputies, and maybe some deputy attorneys general for the audience. We always try to make sure that the perspective we provide is that of the office holder and the staff, and we can talk about why that's so important as we go forward. But I'm looking forward to that as well.
Absolutely, absolutely.
Yeah.
Love to have you in Sonoma, and might actually have to have a glass of wine or two just to
Mm-hmm.
uh, enjoy it while we're there, and get into the ambiance. For those of
Yep.
you who hopefully will be joining us in Sonoma, that's in April and it's coming up quick. Um, I know that the whole concept in your sponsorships and what goes on, our clients are always interested in what's going on in the regulations on the federal side, on the state side, and what's the cooperation between those, and of course
Yep.
what's going on with the state AGs. I know last year at our conference, you guys, part of your sponsorship helped bring in both the attorneys general from Texas and from Idaho, and
Mm-hmm.
that was just a great meeting. I mean, and people, when you get a chance to ask questions one on one with the state attorneys general, and these are the guys that are the enforcers. They're the ones that they take the rules and they enforce them and do that. And now with between the CFPB and the FTC, and even the FCC,
Yep.
and the state AGs, they're all intertwined together, and they're all looking to make sure that our industry, as well as many other industries, are staying focused and treating the consumer what they consider the right way. We don't always agree with the regulators. However, they are regulators, and that's what they do. That's their job,
Mhm.
is to do that. So let's kind of talk a little bit about
Yeah.
what's going on.
Yeah. So Steve, I want to pick up on a comment you made about the invitations we extended, and we are fortunate to have both the Texas and Idaho AG to speak last year, and it's always encouraging and educational for companies to hear directly from the office holders, right? It is when you're in a company and you're trying to make decisions, and we recognize this as outside counsel. Sometimes it feels like it's a black box. You really don't understand the regulator's thinking. You don't understand the process. So part of what we have done successfully with you, Steve, for now almost 20 years is to bring the regulators to the meeting so companies can actually hear what they are thinking and get a sense of the process. So that's point number one. And so again, I encourage everyone to come to Sonoma because you'll be able to hear directly from the regulators as always. The second point I want to pick up on is your comment about the federal and the state agencies being, my term, inextricably intertwined, right? So when the CFPB started, and most folks forget this, the first director of the CFPB was General Cordray. Now, why is that so significant? General Cordray was the former Attorney General for the state of Ohio. So he came into office as a director of the CFPB with the mindset, first and foremost, to encourage federal-state cooperation. And many folks forget this, but at one of his first meetings he attended as a director of the CFPB many, many moons ago, he negotiated and announced a memorandum of understanding with the National Association of Attorneys General. So you had the CFPB director developing a memorandum of understanding with the state AGs, and that memorandum of understanding set out the framework for state AG CFPB cooperation. That framework is still in place today, and you see that framework operationally in action on a daily basis. We see it in action on a daily basis. So every time you see a rule being proposed by the CFPB, you'll see state AGs commenting on it, usually sending a sign-on letter, circulating it through Congress, but they always play a role and they are highly coordinated. In our day-to-day enforcement actions, we see a high degree of coordination. We can see cases where, you'll see state AGs enforcing certain provisions, but you can tell that they're in coordination with the CFPB because a related issue and related provision will be enforced by the CFPB. So you just know that there's a level of coordination, even if it's not formally announced, you can see it in operation. And so we see those relationships, again, that started with General Cordray in office, creating that MOU, that has consistently been in place. And now it's operationalized both at the office holder level and at the assistant AG level, where there's just a level of understanding of sharing information. And so companies need to understand that. And we're going to talk a little bit about what the states have been doing on the FCC front as well. But that CFPB coordination goes on today and is as strong as ever. And you see it in a couple of cases that maybe we'll have time to talk about at the end. But there are a couple of high-profile cases, Steve, that I know you've recently included on the information you send out to the members on a pretty frequent basis, and they can see that cooperation in action.
Definitely. There's pretty much anything now that comes out from the CFPB. There's usually a group of state AGs that buy off on it or are part of it.
Right.
Not all, but a lot of them, they'll either agree or they choose to disagree, and it always depends. But yeah, you're seeing a lot more of it, and I think that's for a lot of reasons. But again, when regulators and numbers, everything seems to move it that much quicker.
Yep.
And sure enough, I think that's what we see a lot of with a lot of different things that are happening.
So the issue that I see, the one substantive issue that I see that I know that state AGs are interested in and learning more about involves artificial intelligence. So on that, 2 points. First, the AGs have been very active through the National Association of Attorneys General to provide comments to proposed rules at the federal level. So, for example, in September of last year, 54 actually state AGs, and that includes the territories, Guam, American Samoa, et cetera, all sent a letter to Congress urging Congress to establish a study committee relative to artificial intelligence and its use in the context of child sexual abuse material, right? That's just one example where the states came together to really focus on that issue. We know AI is an issue based on what we're seeing by way of the enforcement actions. What I would say to this group is that the regulators seem to, at this point, seem to be in educational mode. You don't see yet a flurry of cases involving AI that have been resolved. So you can't, as folks listening to this, think about compliance efforts. Unfortunately, you don't have a series of cases that provides the contours for what the states are focused on. And I can tell you from our day-to-day practice, our perspective is that they remain in learning mode, which is good and bad, right? Unfortunately, sometimes what we see is certain negative presumptions being made about how companies are applying AI and using new creative technology. You don't often get the benefit of the doubt when a question is raised. So you sometimes have to fight through that negative implication. But I would let everyone know here that from our perspective, they remain in learning mode. Again, I do expect over the next year or two for there to be a series of cases resolving AI matters that will again provide some contours for what the state AGs are thinking. Most recently, you have 25 state AGs led by California responding to the FCC's inquiry into how AI technology might make it more difficult for consumers to identify illegal scam calls and text, which is something that this industry should really watch. That letter, again, was led by the Attorney General of California. He noted that robocalls and spam text, in his words, were unwanted nuisances, but that they are the most common way, from his office's experience, that scammers make contact with potential victims. And so for that reason, and because these types of calls and contacts tend to be the topic that consumers complain most about to state AGs. So one of the things that you should always understand about a state attorney general is that they are, in most cases, the regulatory official closest to consumers. So what does that mean? If you're a commissioner at the FTC, right, in Washington, you aren't interacting with consumers on a day-to-day basis. But if you're an attorney general from Ohio or Virginia, you're an elected official, which means what do? You go to state fairs, you speak at Kiwanis clubs, right?
Right.
You are going around your state. When you go around your state, you are interacting with consumers on a regular basis. And the consumers will literally say to an AG, here's my complaint, I've had a call, and this audience would be surprised, I think, with the number of investigations that have started from what would seem to be a simple human interaction where an individual is complaining to the attorney general. And I can tell you from my experience as a deputy AG, I would be sitting at my desk and I would receive a call from then attorney general saying, hey, I either saw this in the newspaper or someone mentioned this to me. Can we look into it? So to understand the important role that state AGs play, it's important to note that since they are so close to the consumer, they are likely to get these complaints and respond to them. And in this case, the California AG focused on the fact that some recent developments in AI have allowed the AI companies to mimic human voices, right? And so the question is, under the FCC rules, should an AI generated human voice, is that a form of an artificial voice of the FCC? Does it come outside the FCC's rules, so therefore it doesn't count as a voice, is an open question. But it's the type of new question that the new technology has created where AGs are weighing in fairly strongly.
Right. And I know, in fact, I think it just came out recently. We ran an article just the last a day or two, with calls that were coming in from AI generated President Biden, talking about voting in New Hampshire. And that's again, it's already teetering on that. So if AI can generate, um, President Biden, obviously AI can generate just about anybody. And what is the legal ramifications, and how does that waterfall down to the industry,
Right.
particularly when it comes to robocalls and scams and things like that, so that obviously our industry is trying to avoid. But since phone calls are the lifeblood of this industry,
Right.
we have to be aware of it.
Right. This industry it is predicated upon effective consumer communication, right? That's its lifeblood. And what you're going to have to do is, I would expect many of your listeners will be responding to subpoenas or civil investigative demands, many of which may not make an accusation, Steve, but they may simply ask questions, right?
Right.
And that's what I do expect over the next year. I don't necessarily expect a flurry of enforcement activities, but I do expect your listeners to receive a number of questions as the new technology develops, as AGs in particular learn the industry, and as they try to understand the limits of that consumer interaction, and companies become creative and learn what consumers like and what consumers don't like. And then, if a consumer is able to communicate with a company effectively and they work out an arrangement that works, and you have to figure out how the consumer likes to be communicated with and then confirm that that's not something that the regulator deems to be inappropriate, excessive, or in violation of the law. So the takeaway point here is that there will be questions asked. I would encourage your listeners, if they receive a question, to understand that often that question truly may be educational in nature and not accusatory in nature. And oftentimes, maybe they can use those interactions to educate the regulator for the benefit of the broader industry.
It makes complete
Yep.
sense, because that's where we're heading.
Yep. Yep. Steve, the next thing I know you wanted me to talk about was multi-state activity. Would it be a good time
Absolutely.
to turn to that topic? So this is by way of background, you have seen an increase of multi-state activity every year. You've seen an uptick as states become more comfortable with working together as a unit across state lines. They have developed areas of expertise in certain offices. Other offices leverage that expertise in the multi-state setting. And you're also starting to see that multi-state activity in the context of litigation, which you hadn't seen as much of. You often saw the multi-state activity occurring around investigations and then ultimately settlements. We've done a number of multi-state enforcement actions resulting in a settlement agreement where you'll see 40 plus states signing on. We're starting to see more multi-state litigation. And one such case that I thought this group would be interested in was filed in Pennsylvania against Mariner Finance. And what's interesting about this case is the fact that you have Pennsylvania, New Jersey, Oregon, Washington, and the District of Columbia filing in federal court in Pennsylvania, which is unusual. You don't see a lot of cases where all the states are together filing in federal court. And in this case, they were filing under the Consumer Financial Protection Act and their state consumer protection laws. And so the defendant filed a motion to dismiss, arguing that the plaintiff's multi-state enforcement action raised a number of constitutional concerns, since the states were the plaintiffs and the localities seeking to enforce a CFPA rather, related to the product of the defendant, but they were trying to do so in a collective concerted action. And it raised a number of very interesting questions. The first of which was and most folks don't realize this, but the Consumer Financial Protection Act was drafted so that the states would have concurrent authority, which means the states have full authority to enforce that act. But the question is really, is that express, or is that something that the states have read into the statute as a way of expanding their authority? But the court here found that Congress both reinforced and intended to expand the role of states in protecting consumers, recognizing, and this goes back to a point I made earlier, and this is from the decision, recognizing that states have historically been much closer to abuses and are able to move more quickly when necessary to address those abuses. This is something that Congress has recognized. You now find this embedded in the case law, and it explains why you see concurrent authority extended to states in a number of instances, including this instance. The most interesting aspect to me, however, was the fact that you have multiple states filing in federal court, and the parties took a different view as to the scope of that state concurrent enforcement actions. So you have the defendants who argued on the one hand that concurrent enforcement authority is limited, and that the states, if they have authority to bring an action under the CFPA, must do so in their home state. That is, they could not band together. District of Columbia, New Jersey, Washington, Oregon would only, in the defendant's view, be able to enforce this provision in a state or federal court in their locality and not in Pennsylvania. They took the position that the statute prohibited this type of consolidated multi-state enforcement action. The court disagreed and read into several provisions in the statute that suggested that the CFPA was structured to intentionally grant not only their enforcement authority, but to have that enforcement authority anywhere personal jurisdiction may be found. So this is a notion, and in our system of federalism, it's interesting. You have multiple states filing in a federal court. We've had a number of cases over the years where we have had states file against our clients, and we've had litigation in state courts, simultaneous litigation in various jurisdictions. But this is an instance where you have the states filing in federal courts. It's highly unusual, interesting issue, which is why it went up on a motion to dismiss. I thought I'd point that out as a case to watch for its constitutional implications. I thought the arguments were well presented, and I don't necessarily agree with all aspects of the court ruling, but I think it's a case to watch in the future.
Yeah, well, we'll definitely kind of watch that one. I know that one got a lot of hits where people were, very interested to find out, what's going to be the status and how do we do this? Because now it definitely changes the strategy of the AGs, because, if you're adding the federal court to your docket of tools,
Yep.
suddenly a lot more states can say, hey, let's look at this and let's go after this, and and this is the avenue that we can pursue.
Yeah, Steve, you're exactly right. If you think about the way these cases normally unfold, they normally begin with an investigation where the states work together to investigate a company. But then historically, if a lawsuit was filed, a state would have to go to its home court, and each state would have to put together a trial team to file in state court. And that's not an easy undertaking, right?
Right.
But here, you have all the states essentially following the Pennsylvania AG's office. It's much easier for them to transition to multi-state litigation when effectively one state is carrying a lot of the load in that federal court. So you're right, it changes the dynamic considerably because the amount of investment a state needs to make in order to prosecute a claim is reduced dramatically if they can simply add their name to pleadings and follow behind a state rather than having to file an independent action in their home state. It fundamentally changes the negotiations because a state's burden of filing an action is reduced considerably.
Right,
Yep.
right. I know we were one of the other areas when you kind of look at the states and the federals. That would kind of leads to the one article we were talking about earlier, where the states have now endorsed the CFPB's rule to regulate fintechs.
Right, right. Right. So what's interesting about that is it's CFPB takes the lead, states support it, but it's the concurrent jurisdiction aspect, right? They in their support, they did not say the CFPB has exclusive authority in this domain, right?
No, no, of
No.
course, no one ever gives up anything. You
Correct,
know that
correct. So
that
it's
that does. You don't have to be a government. You don't have to be a business. Nobody wants to give up anything.
no, so there's an effort to encourage the CFPB to come up with regs and I've said this in several instances that the state AGs um, they have regulatory authority and 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 in many ways you almost want state AGs to use that authority rather than deferring to the CFPB and letting them draft the rules and then enforce it, right?
Hmm.
Again, because of the argument that I read from the court's decision, where state AGs are often closer. So it may be easier for a company to educate a state AG about a fintech product than it frankly may be to educate the CFPB. So I think it's unfortunate in the sense that I would have hoped that the states would have learned a lot first. Not that they're closed to, but I think that would have been preferable, frankly, for the industry if that would have happened.
Probably, but
Yep.
that's they got 19 AGs that were submitted that letter that basically said we support the proposed rule, and of course that leaves the rest of the AGs. They're not opposed to it. They're just not they're just not making their decision as of now.
Right, right. And I will say although the AGs are elected officials, this area, and that by this area I mean consumer protection more generally, is not an area where you find, in most cases, a clear partisan divide, right?
Right.
This is not one of those hot button political issues. Consumer protection is one of those issues that tends to be bipartisan. And you see that in enforcement actions. You see it in what I said in terms of 54 AG signing on to a letter. So as I tell particularly new clients, when they think about state AGs initially, they think about the political aspect. And honestly, in the consumer protection context, the politics is just not all that important in most cases.
Right. Well,
Yeah,
that's definitely true because the AGs of all the elected officials, the AG was always the least political animal
yep,
of of all the positions, where it wasn't a clear red versus blue. It was more along the lines of what's going to be the enforcement and the penalties and the things like that. So it's the outlying areas that still becomes a red blue, but the reality is if you have a blue AG or a red AG, they're still going to enforce them, particularly when it comes to consumer protection. Yeah, you're not going to find an AG that says, "Oh well, just because of my political affiliation, we're not going to slap your hand hard." No, you won't find that. Every
that's right.
AG, I think, is very much as far as the laws and the rules and the enforcement go. No, they're all tough.
They're all tough, and again, it's not a political or partisan issue at all. We see on a regular basis Democrats and Republicans working together on cases. It's unlike other areas that may maybe political flashpoints, consumer protection is just not one of
Right. That's
them.
definitely, I mean, you've got I mean, I know you have RAGA and you have DAGA, but the reality is NAG is, I always love that
Yep.
acronym, but the AGs and NAG are, I mean, they're all lined up in a,
Yep.
pretty much along those lines when it comes to things like consumer protection.
Yep.
Obviously, when you see things like, the whole tobacco issue, which I think really, brought it to a head, everybody sees it, everybody knows it. And the reality is, hey, we are going to protect the consumer,
Yep.
uh, no matter what our political affiliation is.
Yep.
And that's, there's no way to say we're going to be easy because of my political
That's right.
affiliation.
That's
It's
right.
not.
That's not the case. I totally agree. That's not the case.
What about some other areas that you're seeing? Because there's, I mean, robocalls, junk fees, things like that. The AGs they're much more involved now than they were before because you look at it from a federal level and the feds can say, hey, we don't like this, but the AGs again are kind of leading the way in all those areas where almost like the feds are jumping on the bandwagon now, saying, you know what, yeah, we agree, and you know what, let's drop the hammer from the federal level too.
Yeah, but you're right. States have proven to be more nimble than the federal regulators. And one case which really highlights that is the case at the Supreme Court regarding Chevron and what most people have called the Chevron doctrine. And that's just basically that courts should defer to an agency's reasonable interpretation of an ambiguous statute. And it's a case that arises by virtue of a case of Chevron decided more than 40 years ago, where the courts have given considerable deference to agencies. And it's an interesting case because it did create a situation where states submitted amici briefs on both sides of the case. To your point, Steve, the point was the one set of briefs argued that the federal government needed that flexibility to both act quickly and to regulate industries. And another group of state AGs said, no, state courts can do that by interpreting the statute. And so it presents an interesting position for the states, because if this ruling is such that the courts no longer give that deference to federal agencies, you will find at the state level a lot more regulatory activity, right? And as I mentioned early, state AGs under most state constitutions, they have a regulatory authority and they have an enforcement authority. So one of the things we're monitoring is that in this case could inadvertently create a scenario where there's more regulatory activity at the state level through state AGs than we see today. So it's the case we're watching closely. And again, it highlights the relationship between the federal government and the state government. But it's to us, it's one of the more important cases that make the direct implications on state AGs may not be obvious, but they'll play out over the next few years.
Absolutely.
Yep.
I mean, it's just, it keeps going and going, and
Yep.
the way they look at it, it's from our standpoint, to be in compliance is, you've got federal compliance, you've got state compliance, and you've got, sometimes they're in conflict, and hey, we've all gone down that path, so it's tough, but
Yep.
that's why you need a good compliance attorney to help you out there, right?
Well, Steve, can I give you my one closing practical tip, because you reminded me of it in your comment about compliance, and that is, and for all the folks in the audience, it's the I would encourage every company to closely monitor settlements. If you monitor settlements, you can track the development of the law, And perhaps more importantly, you can track the evolution of a regulator's position on an issue. They tend to create a regulatory structure through their enforcement actions and their settlements. So the practical tip, which you reminded me of when you mentioned compliance, and everybody has a robust compliance department, but I would encourage everyone to incorporate into that analysis settlement agreements and go beyond simply looking at the settlement agreement for the amount paid by the company. That's obviously important, but I would encourage your listeners to look at the injunctive relief provisions, because that's where you see the opinions and the boundaries of the law as articulated by the regulators. And you can shape the contours of your compliance to conform to the regulator's expectation, or at least know what their expectations are as you make a business decision. So I wanted to make sure that I got that practical tip in before you closed.
Oh, I love it, and it's so true because hey, this is I won't tell your hourly rate, but that's a lot of good advice for what everyone's paying to watch this. So you know what, I think we're good on that because that's if everyone's there, and that I mean if that's not an incentive to come out to Sonoma to ask follow-up questions to you, I don't know what is. I really don't. It's a good opportunity, and that's kind of what we look at. I mean, Ashley, you're a plethora of information, and there's so much stuff we could discuss. I know some of the stuff you're working on, some of it is cases that you guys are actually involved with
Yep.
because of your clients and stuff like that. So obviously, we're not going to touch those with a 10-foot pole. Maybe by the time Sonoma comes around, we can.
Yes, yes, yes. Yeah,
So
and I certainly want to. I will do my best to share as I can in an appropriate way lessons learned and observations that benefit members of the industry, so we can all conduct our business in a way that conforms with the law and doesn't draw adverse scrutiny.
definitely, and I know that as we finalize whom is coming this year to the conference. We will obviously, in our very quiet, shy way that we send out notifications to everyone, let everyone know who's coming. Like I said last year, both Idaho and Texas when they came. The questions were just forthcoming, and everyone got that chance to, when you can actually sit down and talk with an AG, and ask them the questions that you feel are impacting your business. That's about as relevant as you can get, because here's a person that you've got maybe a minute or two to do an introduction, get a little feedback, and then find out who the right person in their office is to talk to,
Yep.
because the AG is the AG. But we all know that the deputy AG does really all the work in the offices. That no plug there, Ashley. But the reality is they do. I mean, it falls down. Everyone knows the staff is involved, and those are the people that you really do have the day-to-day conversations with, to make things happen. And that's, you want to build those relationships. You want to have that. I think every time you speak, you always say that same thing. He says, "Hey, get to know your AG's office. Get to know who's the right person to contact, because eventually, sooner or later, you're gonna get a notice from that AG's office, whether you've done nothing wrong or whether you've done something wrong." The idea is they're trying to find out information, and ignoring it is not the answer.
Not the answer. Not that would not be prudent. Yes.
Yeah, so I mean, there, you really want to, if you're in compliance, there's no reason, they're asking questions, you answer the questions, and you should be good. But the idea behind it is, you've got to communicate with the AG's office, and you've got a lot of AGs out there that are looking, as well as the feds, so that you best be involved and you best be part of it, and do it. And this is a great way to sit down. I know with AG Paxton sat down with a lot of people
Yep.
when we were in San Diego last year, and really chatted. Just wanted to find out more information, learn more things about the industry, find things out, get contacts, because they're interested in things like that too.
Yep.
Because who knows how long they're going to stay in the
Well,
political
and
arena.
yeah,
And then,
yeah, and Stephen, they want to understand an industry, as you said. That's the main point. They are learning an industry, and again, they regulate industries in various segments. So they have a lot to learn about this industry in particular. Yep.
absolutely. I always will remember when we were in Half Moon Bay and we had the three AGs in Nebraska. The Nebraska AG, somebody asked him, he says, "Is it okay if I turn in somebody else that's violating the law and I know they're doing?" And his response was very clever because he said, "Yeah, we're like sharks in the water, and if you want to throw us a piece of meat, we'll tear it up." So, hey, worst comes to worst, you want to throw your competitor under the bus for doing something wrong? I'm not getting involved, but hey, if you want to, that's up to you. So you find out lots of different things out there, and that's kind of what we're looking at. But Ashley, I want to thank you for your time
Yep. Thank you, Steve. I appreciate
because
that.
it's always a pleasure talking to you.
Yes.
It's always good to catch up, even though you're on the East Coast and I'm on the West Coast. I'm so glad you're coming out this year.
Yeah.
Like I said, you're always full of information that everyone should listen to and understand. And occasionally, if somebody really needs you, that they're going to bring you in. So that way,
We're here to help, Steve. We're here to help. Thanks for inviting me.
gotta love it. And with that, we're going to conclude this session. And like I said, if you've got questions, you've got more information that you need from Ashley, let us know, and we will certainly pass the information on. If not, you can go right to the Troutman website, and Ashley's leading right at the top of that. All you have to put is Ashley's name, and then it'll immediately pull him up, and you can send him the information yourself too. So with that, we are in conclusion of this podcast. Again, if you ever have any questions, any needs, anything like that, just send the information directly to Credit and Collection News, and we will get back to you as soon as possible. With that, we are adjourned, and have yourselves a great day.